Welcome to Young Legal Minds. This video is on the final element of an actionable misrepresentation, which is inducement. So, in other words, that false statement of fact that I went over in the previous videos must have induced the representee, the contracting party, into the contract. It must be the reason why the party entered into the contract. Inducement is broken into two parts. The first part is that the false statement of fact must have been the reason why the party entered into the contract. It must have been material to the party's decision to enter into the contract. The second element is reliance. So for material, the courts use an objective test. So they will ask themselves, they'll look at the scenario, they'll look at the situation, and they will ask themselves, would the reasonable man have entered into this contract because of that statement? That's essentially the question. Was the statement material to the party's decision to enter into the contract? And the case you can use is Smith and Chadwick. In Smith and Chadwick, the representor represented that in his particular company there was a famous director. He was a celebrity, and he was part of the company, and he said this to essentially induce the other party into that contract. However, the representee had never heard of this famous person, didn't know who he was, didn't really care, to be honest, and so it was held that false statement of fact was not material to the representee's decision to enter into that contract, and so it hadn't induced him into it. It wasn't. It didn't satisfy this final part of stage 2. Reliance, however, is based on a subjective test. So they'll look at the facts. They will try and figure out whether the party had relied on it by looking at the intent within his mind. This is the difference between the objective test and the subjective test. The objective test is based on would the reasonable man, blah blah blah. The subjective test is would the party, or did the party, blah blah blah. So the question for Reliance is, did the party rely on the statement? And I put the case of Atwood and Small up there, and the reason being is because in Atwood and Small, the party was the representee wasn't too sure as to whether the representor was telling the truth, whether the statement was true. So he conducted his own research. He hired a third party to conduct some research, and the third party came back and told the representee that the statement was actually true. The statement was actually false. So the third party actually made a mistake. And when the representee then entered into the contract with the representor and found out that the statement was untrue, it was false, it was held that actually he didn't rely on the statement. He relied on the third party's research. He relied on the third party's view that this statement the representor had made was true. And because of this, because he had not relied on the statement itself, but he relied on the third party's view, the third party's statement, that element of inducement had not been satisfied, and so there wasn't an actionable misrepresentation. But what about situations where the representor gives the representee the opportunity to assess the statement, and the representee then declines this opportunity? So where party A, let's say party A is the representor, he's made a representation to party B, and party B is the representee. Party A then says to the representee, here, take a look at these documents if you want further assurance that this statement I have made is true. If party B, the representee, then rejects that opportunity, turns it down, can he still seek a remedy under misrepresentation? When put that way, you would think probably not. However, this is not the case, and the representee can actually still seek a remedy, as shown in the case of Red Graven Herd. So Red Graven Herd shows that where the representee is invited by the representor to assess the statement, the validity of the statement, if that opportunity is then declined, that will not stop the representee from being able to seek a remedy under misrepresentation. And I think this is a public policy matter. I could be wrong, but it makes sense if you think about it, because if, let's say, because I mean, we all did this when we were kids. We all said, "Oh, if you don't believe me, ask so and so," or something along those lines, knowing that by saying that they wouldn't ask that person, because by saying that we are making it clear that we have witnesses, that someone else knows the truth, and by doing that, it's almost like reverse psychology if you think about it. It's like saying, if you don't believe me that this statement's true, check the papers, and they're going to say, okay, he's got papers, he's given me an opportunity to assess whether it's true, it must be true, therefore there's no need for me to assess the papers or to look at the document. And I think that's essentially the reason why this is now the case. I think that I think it's a public policy matter, and I think it's to stop rogues, I guess you could say, from using these tactics and so on.